Sure. Yeah. Chief Judge, all persons that court draw near, give attention, and you will return. May God save you. That takes the state of Florida and that's on the You see it? Perfect. Are you seeing it? Mm-hmm. So don't laugh too much. Don't laugh too hard. I'll leave you. You nervous? No. All rise. The Court of Appeal in for the 6th District of the State of Florida is now in session. The Honorable Dan Traver, Chief Judge, presiding. All persons having business before the court, draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
All right, thank you. And good morning, everybody. Welcome to an oral argument session of the 6th District Court of Appeal. I am Dan Traver. I'll be presiding today. I'm joined on this panel to my right by the Honorable John Starchel, and to my left by the Honorable Patriot Brownlee. We have two cases that we'll start with this morning, and with the kind accommodation of the lawyers involved, and thank you again, gentlemen. What we're going to do is consolidate these two cases for purposes of oral argument only. They are case number 23-2152, Richard Lee Massey versus the City of Florida, and case number 23-2165, Andrew Bryant Sheets versus the City of Punta Gorda. Before we ask Mr. Heindel to come to the podium, I would remind everybody that we are streaming live on YouTube. If you haven't already silenced your cell phones, we would be grateful if you did. Mr. Heindel, I'm going to move you up to 30 minutes as we discussed. Typically, I would leave 5 minutes for rebuttal. Is that sufficient, or do you want more?
I would like 12.
12 sounds good. Whenever you're ready, sir.
Thank you. Please support. Your Honors, in this particular case, I'd like to start it out by framing it in the appropriate legal metric, which I consider due process and the intent of the evils to be remedied. Now, in this particular case, I think about it as like a debt. If Mr. Sheets and Mr. Massey disobeyed the law and they were fined, they owe a debt, their debt would be a monetary fine. In fact, they were fined in this case. Now, if the city wants to collect that debt, they have a very, very strict means to do so. They can lien their properties, which they did. And when they collect those liens, or when they pursue it, then they can put liens on liens. And also, when they collect that debt, they can charge cost and attorney's fees to collect that debt. And I would submit that the city owes a debt to Mr. Sheets and Mr. Massey to not bring charges unless they have competent, substantial evidence. And, well, this is in fact, when this case went up on appeal, the court determined, well, they didn't violate the ordinance. I'll say more about that. But in order to make that finding, there had to be a finding that there wasn't competent, substantial evidence on that. In other words, the words they used didn't depict sexual functions that were used in a political protest manner. He didn't violate the ordinance. That's one of the findings of the court, one of the decisions. Now that, all the city had to prove to sustain that is not persuasive, not burden of proof, not preponderance, but competent, substantial evidence, which is some evidence to every issue. And I think the city owes a debt to my clients not to charge them unless it's with competent, substantial evidence. But they didn't. They charged them without competent, substantial evidence. In fact, that was the whole brunt of what the city was doing. They wanted to get rid of the words. In fact, if you read the record, you'll say there was a memo sent out. The words themselves, if those words were said, that's what we're going over. It doesn't matter the context, though. I don't want to get into it. Now, we might not like those words, but they have legal right to use them. Though I might not like them, if the city can tell them they can't use words that I don't like, they can also say, I can't use words that I do like. It's oppression. It's just to open the door to oppression, and oppression of free speech. Now, so in this particular case, city owes a debt, but the city said, even though you went to court and you won, we don't even have to pay your costs. We may have to pay costs, attorney's fees, liens, and everything else to collect their debt. You see, you have to pay, we're going to deny appellate costs because there's no rule or statute. We're not going to stipulate to the record, and that's going to make their costs run up. In Massey's case, his fine was like $500, and it cost him way more than that, just the cost of appeal, which he couldn't be reimbursed, which he should have been reimbursed. So that's not just procedural inequity, that's oppressive. In due process,
Can you address the substantive basis for entitlement to fee recovery? You've got two that are outlined in the briefs.
I was going to mention costs first.
Go ahead, I'm happy to talk about costs first.
Yeah. So, the appellate costs, the nature of pursuing an appeal like this is not crystal clear. In fact, I had to go and find this Florida Bar article, volume 82, number 5, May 2008, and it describes how to appeal one like that. But without going on and being cognizant of time, the essence of it is appeal pursuant to the appellate rules, the rules of appellate procedure. We go by those rules. And the city said, well, you got to have a rule or a statute. The judge didn't go that far. He said there's just no basis to award attorneys. No basis. He didn't exercise discretion. I think we all know that that the rule says attorney's fees to the prevailing party. In the appellate cases that recently came down in Guardianship versus Bloom, it's 251 Southern 3rd, 1026.
talks about the court that's sitting in its appellate capacity being the one to exercise
That's
discretion.
right.
So if we're, oh, go ahead.
Now, my judge, I know it's a little, he's sitting in, he just said, he said, I have no basis. There's no basis whatsoever. He didn't say there's a prevailing party or I don't have discretion. He just, I don't have any, I can't do this because there's no rule, but there is a rule. Was there a question on that? But,
Yes, I think that the chief and I have perhaps the same question, and I wanted to defer to him, but, all right, you've referenced the rule, so, and I understand that the circuit court is sitting in its appellate capacity, correct? And so, how is it that the the circuit court sitting in its appellate capacity, if I read the rule, it states, costs shall be taxed by the lower tribunal on a motion served no later than 45 days, et cetera. And so I'd like you to address the issue of tax shall be cost by the lower tribunal. So
this whole scheme has to be put in the envelope of due process. Anything you interpret on that. In fact, we couldn't have appealed without an appellate case saying you have an appeal right to due process, because there's nothing in the 162 that gives you the right to appeal a constitutional issue. So you have to put this in terms of due process. I have to say it's a bit odd. Who is the lower court? The lower court it's a quasi-judicial function.
Well,
They can't award.
So I think that,
Yeah.
I had that initial question. It's an interesting one. If you look at 9.020, which is the definitional section of the appellate rules of procedure, it has a definition for lower tribunal. And my reaction was kind of initially the same as yours, which is what is a code enforcement board going to do with a cost motion filed before it? How are they going to know how much an appellate transcript costs or whether it's reasonable or et cetera? But right there, if you look in the definition in 9.020E, it actually defines lower tribunal as to include a board.
Well,
So my challenge with this particular argument that you're making, and except for the sake of my question, that I agree with you that there didn't have to be an independent basis, that 9.400A is all that matters. 9.400A says that motion needed to be filed with the lower tribunal to include the board.
And I'll say you'd have to, that's why the courts say you have to fill in the gaps with due process. To file a motion.
But where would you fill in the gaps if the Florida Supreme Court had prescribed an identical rule? Because it seems that your arguments start hitting each other in the head at this point, because if you're going to say, okay, due process is the Florida Supreme Court saying that the court, in this case, the court sitting in its appellate capacity, will award costs. You don't need any other statute. That's your due process argument there. It starts to run into the other side of the statute of the rule, which says, hey, as a condition preceding to that, you've got to file that request in the lower tribunal first, which doesn't appear to have been done
Well,
yet.
that's not really a lower tribunal, it's a quasi.
But I'm telling you that and maybe you want to address this on your rebuttal if you get a chance to look at the rule, but 9.020E specifically defines lower tribunal to include a board. And that's my challenge.
I think you'll have to address the core issues in the case. Does that violate, we got to interpret this using due process. A motion to the lower court, to the code board is meaningless. They
Let me
cannot.
phrase it in a different way then, and I'm not being argumentative with you, Mr. Heindel. I'm just saying this is the position that we're in. Are you asking us, and I'll ask an intentionally provocative question, if 9.400A comes from the Florida Supreme Court, which is binding on us, are you asking us to write an opinion that overrules the Florida Supreme Court?
No, I'm just asking you to interpret the rule as not contemplating this particular situation. The meaning of the rule was not to include jurisdictions that had no power to award costs.
So why would they have written board in the rule?
Why would they have what?
If they included boards in the rule, why would they have included that?
Maybe some boards have the power. They don't have the power. We took the constitutional issue, and tried to present it to the board, and they don't have the power to rule on the constitutional issue.
I mean, I grant that they might be confused because it doesn't come up every day, but if they said we're not gonna do it, then I think that you would be able to go to the circuit court sitting in its appellate capacity and say, hey, the board here, even though it says board under 9.020E, they're not doing what the Florida Supreme Court directs them to do.
Well, I would say, Your Honor, there's, there's only so many angels you can stack on the head of a pin. That's not a legal argument, but,
I've made that argument myself sometimes, but I don't necessarily know that it fits here when it seems that we've got a rule that directly prescribes what the process
well,
is. So you're talking about due process, and these rules are in line with the Florida Supreme Court's constitutional power to write rules regulating litigation process. So in this sense, they've regulated the process.
yes, but when they regulate the process to the extent that one of their rules is meaningless and a nullity, I think that's what you have to suggest to the Supreme Court, or either just, write a detailed opinion and we'll ask the Supreme Court to change it. I mean, that's all I can do. If that's the way you feel, please put that in writing.
How is it,
Because it's very confusing. We'll ask the Supreme Court to deal with it.
how is it meaningless and a nullity?
Just don't shut us down in PCA land where we can't even, other attorneys might make, if it is a mistake, they'll be making the same mistake. Write it, and we'll take it to the Supreme Court.
Well, look, I'm not, the reason that I ask questions, and I think the reason that we all ask questions is because we want to understand your arguments better. I'm not taking an adversarial or an aggressive tone with you.
Well,
I'm just basically saying, this is how the rule, this is how, and I grant you, it's not straightforward, especially when you're talking about a municipal code enforcement board and a circuit court acting in its appellate capacity. It's not like Bloom, for example, where you had the typical situation where the court under the first part of 9.400A is us. It's a very different situation. And I acknowledge that takes a second. But do you disagree that when you look at 9.400A and 9.020, it effectively just slides those two tiers down a level?
I'd have to disagree. That's a reason. And I'm not trying to be adversarial. I'm just saying, and by saying, please write that in an opinion if that's the way you feel so we can take it, because it's such an inequity and it's such an injustice to have to present a motion before a board that has zero power to do anything like that. It doesn't even have a procedure to do it. I mean, we wouldn't even know where to send it. We tried to, send them appeal stuff. We don't, there's just no mechanism. I'm just saying it makes such little sense that you've got to, put due process into this whole situation. Or in fact, the whole ordinance should fall. I mean, 162 should fall as, in the Michael Jones case versus Seminole County. He says, they say, this case is ordinary, but some boards take unbridled and arbitrary actions. They may well deserve Jones' characterization of kangaroo courts. In this case, I was yelled at by one of the court board members. Jurors told to shut down. My clients were called bozos. There was one board member, putative juror, there mentioned it might be unconstitutional. He was fired from that board in about 6 weeks. If there's indeed a process, I'd have to assert this whole scenario, 162 is unconstitutional, to deal with a situation like this, where it's called potentially a rogue court or a kangaroo court by some appellate decision. I mean,
you're about 3 minutes away from getting into your rebuttal and you haven't addressed the fee issue yet. Do you want to do that, or do you want to?
Well, all I'm saying is that, the question you brought up, and I don't take it as adversarially, I understand consciously you're trying to do your job. I'm asserting that, due process should be considered in it. We couldn't even appeal this case. in 162 says you can appeal based on competence, evidence and so forth. One court says you can't appeal it because it's not in the statute. And the appellate court says, yes, you can, you violate due process. So, and to tell the Supreme Court, they wrote a rule where it can be, a violation of due process. Well, I know that would be a hard thing to do.
Wouldn't they then have to list what cases, I mean, how would they functionally even do what you're suggesting? So if we were to suggest to them that this does not work in the case of, as you put it, kangaroo courts or whatever boards or whatever it is that you're characterizing as such, would they then modify the rule to say lower tribunal unless, and now there's magical criteria?
Well, I'm sure they have brilliant writers that can make it clear enough so that it won't result in such an oppressive scenario. It's so difficult even to appeal one of these cases with all the arcane rules. It really is.
Let me ask one more thing just about the shifting
Yes.
tiers. The first part of that rule talks about costs will be taxed in favor of the prevailing party unless the court orders otherwise. It seems to me that one challenge with melding together the court and the lower tribunal is that you're effectively exercising your discretion against yourself. So in other words, if you look at Bloom, which you cited, basically that stands for the proposition that the court, which in that case is the district court like us, in that case the second DCA, I believe, says we're going to exercise our discretion to say no costs in this particular situation. So lower tribunal, even though like somebody filed a motion in front of you, you're not allowed to rule on that. Do you see the challenge with merging the two levels together? I almost feel like this is a rules committee discussion as opposed to anything else, because the rules committee would seem to be addressing these situations.
Okay, well, that should make this whole 162 kangaroo court go down in flames as unconstitutional. You really should, because think about the scenario I just painted for you. This is horribly oppressive. Take that rule. They try to put it in the land development code. The saying says you shall not wear a sign, you shall not hold a sign. Think about smothering a ordinance against free speech in an open forum in the land development code, in that covering something you could wear on your clothes like a sign in an open forum. And then you put this in a kangaroo court and you end up with a finding like this case, no competent substantial evidence, there's no way around it, and end up with this kind of scenario. It's such a mess and has such, it's so prone to abuse. Just take whatever you want to, city, file it away in that land development code associated with land, and take away your rights to free speech. Make the procedure so arcane and unable for anybody to follow, reasonably to follow. And you just got a clear due process, constitutional deprivation to the whole thing. Now, there's probably better arguments to address your questions. That had I had the time, maybe I could come up with a better scenario. They're very good questions. But just to answer Judge Traver, Your Honor, the court cannot exercise discretion against the prevailing party. That's what the Bloom case says. The discretion only goes to, well, do I put off these costs or did you not really prevail? The rule is interpreted for due process or whatever purposes that the prevailing party wins the cost. And that's the Bloom case and those other cases.
You're a couple minutes into your rebuttal time. Do you want to keep going or do you want to reserve it?
Well, I guess I'll reserve it.
Okay.
My name is David David Levin. I'm the city attorney for the city of Punta Gorda, Florida. I wasn't expecting to be somewhat sympathetic to Mr. Heidel, but I did find myself to be somewhat sympathetic to him dealing with your question until he besmirched the integrity of the Code Enforcement Board. And so if you permit me the opportunity to say, City of Punta Gorda Code Enforcement Board is not a kangaroo court. It did not deny his client due process. And it did in fact make a determination based on the competent and substantial evidence in the record. And that was that his clients violated the code enforcement, the provision relating to our sign code that's in our land development regulations, regulating all sorts of signs on all sorts of properties within the city as it related to indecent speech. The problem that we faced in the appeal to the circuit court was that the circuit court determined that the actual words that were used on the sign and the context of the words that were used did not fit the definition that we had in our ordinance. And so therefore, while the Code Enforcement Board correctly found that those words were used in violation, technically, theoretically in violation of our code, judicial interpretation determined that was not correct. And so the case was the Code Enforcement Board's order was vacated based on the failure to provide evidence of the types of words that were defined in our ordinance as opposed to the generic classification of the words in the ordinance. And I also want to point out that we spent a lot of time trying to make our ordinance consistent with the requirements of the U.S. Supreme Court's decision that came down relating to sign codes and the requirement that sign codes be, for the most part, content neutral. And the provisions of the code that addressed the defendant's codes in this case, signs in this case, was a very small portion of the overall sign code that was adopted in order to make our code, which was consistent with many other codes around the country, many other codes around the state of Florida, that discriminated between certain content on signs. You could have you can't have a yard sign, but you can have a garage sale sign. So you can have a for sale sign for a residential property, but you can't have some other type of sign. So our code was totally rewritten in order to address the requirement of the U.S. Supreme Court that it be content neutral. And the provision relating to indecent speech came about in our sign code after there was a proliferation of flags being displayed in residential neighborhoods with children that used the F word. And the city council asked, was there a way that we could provide a provision in our code to address that, trying to protect the interests of the children from being exposed to such language that their parents probably wouldn't want them to be exposed to. So I spent a considerable amount of time doing legal research on that matter and came up with the FCC versus Pacifica case, which is a case involving George Carlin monologue broadcast on the radio during the daytime to be listened to by children that used the 6 or 7 deadly words that you should never use. It came out in the 70s, and I'm sure it was the most popular case in law school at the time I was there to read to see what the Supreme Court was saying, and his monologue was in the appendix to the decision. But the point is that in that case, the FCC came up with a definition distinguishable from the definition of obscene language, which was always in everybody's code. You can't use obscene language, which clearly, based on the U.S. Supreme Court's decision as to what is obscene, wouldn't qualify for anything that would be on anybody's sign. So the real concern was the use of indecent language, and the FCC defined indecent language in the manner of sexual functions and other types of things that were clinical in nature, and we defined that similarly in our ordinance. So when his clients were presenting signs in public places during times of day that could be viewed by students, children, our police officers did in fact find them to be in violation of the code as it was written. Unfortunately, our circuit court judge disagreed with us, and we lived by that. So then there was the motion for fees, and in our presentation to the court in that case, there was like, throw the spaghetti against the wall and see what sticks. There are all sorts of different allegations as to where was the statutory basis for getting entitlement to fees and costs, because Florida follows the American rule. Now, the judge in his decision didn't make mention to the American rule, but clearly relied upon it. I cited it in my brief, and essentially the
Is
American.
costs always wrapped up in that prevail in the American rule where everybody pays their own fees and costs unless there's some, statutory or contractual basis?
Yes,
And you believe that the cost is wrapped up in that and that does not only pertain to fees?
yes, the Israel case that I cited in my brief is specifically related, it specifically mentions costs as well as attorney's fees.
So what are we to do, excuse me for interrupting you, in 9400, what are we to do with that language shall? Costs shall be taxed in favor of the prevailing party unless the court orders otherwise. Can that be squared with your suggestion that there has to be a contractual or statutory basis? I mean, taking your argument to its logical conclusion, wouldn't the rule necessarily be where there is a statutory or contractual basis for cost, then cost shall be taxed in favor?
Are we talking about Rule 9.400?
Yes, sir.
Okay.
Section A.
Yeah, so there's case law that would suggest that rule is derivative. In other words, there needs to be a separate statute that would authorize costs and recovery of costs and or attorney's fees in order to apply that rule. And so that is consistent with.
But again,
the
if we go
American
back to the idea that we can't overrule the Florida Supreme Court, and that rule 9400A says you do it. You're citing back a 1985 case from the Second District Court of Appeals, which isn't binding on us. So if the question is, do we follow the Florida Supreme Court's directive that says you gotta do it, versus a second DCA case that says that there's gotta be a statute from 39 years ago, I guess I'm a little bit skeptical about that argument.
Well, the Florida Supreme Court has clearly recognized the American rule. And so.
As it relates to fees.
And costs.
No, I mean, otherwise the rule wouldn't say what it says. Do you have something from the Florida Supreme Court, for example, that says, and I'm not saying anything other than a sister court's decision isn't binding on us. But do you have anything from the Florida Supreme Court that says when we say shall, we mean shall plus an underlying statute? You've got Israel, right?
Yes, but I'm not specifically referencing 9.400. That's my dilemma. So I think that the deal is that you have to read that in context of what the recognized law is as it relates to fees and costs.
But if we do that, and before you pivot, I just want to interrupt you again on it. So if you look at, there is a distinction, and I would think meaningful, and then it goes to this exact argument between 9400A addressing costs and then 9400B addressing fees. And unlike the language that I read to you regarding costs, the attorney's fees subpart states, with the exception of motions filed pursuant to 94, we'll just skip it, a motion for fees shall state the grounds on which recovery is sought, right? I mean, presumably that's a substantive basis, and shall be served no later than. So they have to state the grounds upon which the recovery is sought, unlike costs, which shall be taxed in favor of the prevailing party. Why would there be, if these were treated as one and the same, why in the world are they treating them so differently?
I don't have an answer for that, just like I don't have an answer as to why the legislature isn't always consistent with the legislation that they adopt. And I think particularly with respect to code enforcement, which is a totally different animal and is totally statutorily created. There's, to kind of answer the question that you posed earlier to opposing counsel, code enforcement boards are creatures of statute. and they only have powers and authority provided for by the legislature. And the legislature, in creating Chapter 162, didn't do an awfully good job of addressing all the contingencies that may be needed to be addressed by the Code Enforcement Board. And there's no provision in there whatsoever relating to taxing of costs or attorney's fees to the prevailing party. So frankly, it would have been useless for the respondent to file a motion for attorney's fees after the circuit court in its appellate capacity ruled in favor of them on the ultimate vacating of the order.
What about your colleague's argument that if he'd have followed the rule in 9400A, the bottom part, and filed a motion to tax costs in front of the Code Enforcement Board, that they wouldn't have addressed it?
Well, fortunately, I serve as the prosecutor to the board, and we have other attorneys that are outside of the firm that I belong to that represents the city. The outside counsel represents the board and would have to answer that question. I suspect that they would be stumped the same way I would be to say that there's nothing in the statute that would allow the Code Enforcement Board to do that. And so they would run the risk of having the Code Enforcement Board take an action that they didn't have the lawful authority to do.
You understand the situation that it puts, and let's just say we can agree to perhaps disagree as it relates to the necessity of an anchoring statute on 9.400. The last point I'd make of that is that this rule was promulgated by the Florida Supreme Court 7 years after the Israel case. So they might have looked at the Israel case theoretically and said, that's not right, and we're going to do it this way. So presume for the sake of my next question that I don't buy your argument on 9.40, obey the first part.
Sure.
You understand how that might put your colleagues' clients and people like that in a pretty challenging situation if we're going to say, okay, that argument isn't right, but we might affirm on the notion that the lower tribunal, which is defined as board in the Florida Rules of Appellate Procedure, is where the motion has to be filed. If the response from the city of Punta Gorda is, well, if you do that, we can't do anything about it. You understand that there's a bit of a catch-22 from the perspective of people like your colleagues' clients?
I understand that, and almost, I won't say every day, but in my job as city attorney, I have to deal with statutes and rules of procedure that deal with municipal government that is separate and apart from like state government that deals with, that acts under the Florida Administrative Code, that has a whole bunch of stuff, including provisions related to fees and costs. It's all absent as it relates to municipal government. And so it's not uncommon for me to have to say, well, there is no answer to a question because it's been overlooked by the legislature, possibly in this case, by the Florida Supreme Court, because these matters don't come before the Florida Supreme Court that often to make it, to know and have it in its forefront of consideration. How do we deal with that particular case that we know how we dealt with in many other circumstances, a civil action or action under Chapter 120. There's a case involving Charlotte County where it was a code enforcement decision and had to do with a due process. And the court ultimately decided that, well, in the absence of a provision in the statute that says about how something is going to be done, we need to kind of invent something to be able to provide appropriate due process. I don't know if that's the answer to the question, but it also points out the fact that it's not uncommon for Florida rules and Florida statutes to don't have an answer as it relates to code enforcement or municipal government. I just had recently a situation, forgive me for saying a war story, but to take an appeal of a quasi-judicial decision, which is what most of our decisions are that don't involve creation of open ordinance, so rezonings, for example. The word appeal is used, and there's a process under the rules of appellate procedure where you can go and do a direct appeal under, 190 or something like that. And if you don't do it that way, you have to do a petition for certiorari. So it's one or the other. The courts have said that a quasi-judicial hearing of the decision involves the requirement for a public hearing. That's not really entirely accurate when you look at what the definition of what a quasi-judicial hearing requires in terms of the criteria leading up to the decision. And so because there's a great deal of uncertainty as it relates to how the municipalities make decisions, the counties make decisions, in contrast to the way the state law makes the decision, the state administrative agencies make the decision, there's gaps. And unfortunately, I don't have an answer for you other than the fact that it still seems to be inconsistent with the American rule that requires litigants of both sides to be responsible for their own fees and costs.
Could, I keep doing that to you today.
No, I'm doing it too.
Could they have lawfully obtained a cost judgment against the city?
I wouldn't know the procedure for accomplishing that, no.
I guess I understand what you're saying, which is that if the Florida Supreme Court in its rulemaking capacity hasn't promulgated an applicable rule, that clients like yours might have questions as to how they need to proceed as matters of procedure. But it appears in the context at least of 9.400A and 9.020E that they have promulgated a rule. Otherwise, what does board mean in 9.020E? And if I look at it, it's a list of bodies. And what it says is the court, agency, officer, board, commission, judge of compensation claims, or body whose order is to be reviewed. So in that particular context, I accept what you're saying is that the rules of appellate procedure are not primarily directed towards municipal code enforcement boards. We can agree on that. But what about a situation where it appears to be?
So the dilemma I have, and I don't mean to repeat myself, is that the legislature hasn't given our code enforcement board the authority to deal with fees and or costs. And I would hope, just as the legislature is presumed to know the law that they have to deal with, when the Florida Supreme Court makes rules of procedure that are applicable to administrative bodies or municipal bodies, that they're also familiar, it's a fiction, but they're also familiar with the limitations of the boards and authorities that they may be putting under the framework of a rule that can't be accomplished because the legislature hasn't given them the tools to do so.
So you agree with your colleague then, is that correct? That there is no way for them to have filed a motion for costs at a minimum in front of that board? Is that what you're saying though, that they don't have the authority?
What I'm saying is they could have filed a motion, but there's probably no way that the board, if given the authority, and given the advice of the attorney that represents the board, it would indicate that they're an administrative agency, have no authority to act without statutory authority, and there's nothing in 162 that would give them the authority to assess costs.
So let's play that out. Say he appeals that decision to the circuit court sitting in its appellate capacity, and the circuit court says, just like it did in this case, hey, you're wrong. Or you overstepped your authority, or you didn't fully apply your authority, and I'm directing you based on 9.400A and 9.020E to handle these gentlemen's cost motions. Does the board act in that situation?
Well, if that was the case, given the fact that, the statute is clear that there's no authority, and the case law is clear that without authority they can't act, I suspect that our city would have been more inclined to take an appeal to address that.
Up to us.
But more than likely, they probably would have paid whatever the costs were, because costs are expensive and attorney fees are expensive. to a municipality that has the responsibility of enforcing its regulations.
Does sovereign immunity apply to a cost judgment?
I have no idea. I wouldn't think so.
So sovereign immunity doesn't preclude a money judgment against the city?
I honestly don't know much about judgment, in money judgments. It's not my area of expertise.
Fair enough.
Having looked into a little bit, it's complicated.
That's probably why I'm staying away from it. I'm an environmental attorney primarily, and municipal attorney secondarily.
Fair enough. Anything else you wanted to add?
No, I just, you're right, there may not be a specific decision that I can rely upon at the moment as it relates to the costs under the American rule, but clearly the attorney's fees are covered by the American rule. I think that the judgment of the lower tribunal should be upheld on that basis. Thank you, Your Honor.
Thank you.
I wish I could address some of your very important questions better. Well, one reason why it's difficult, because the order of the court didn't rely on anything, didn't even mention not filing. He just said, we can't do it. There's no basis. Didn't mention you need to file anywhere. Opposing counsel never brought that up. So I really don't think it's a role of the court to bring up arguments that weren't brought up, not only on the order, opposing counsel, but also on the order of appeal. It's not in there.
There's a doctrine that's blessed by the Florida Supreme Court that says that the trial court is right, but for the wrong reason, we can still affirm. And that might be why you referred to it as PCA land. Why there are situations where that happens. But let's say for the sake of my question, that I agree with you, that the trial court's wrong about that. But ultimately, if it's right, that it could give you costs, but for another reason, the one that we've been talking about this morning.
Mm-hmm.
Cannot that be under the tipsy coachman doctrine a basis for affirmance?
I don't think a judge sitting in his appellate capacity has ever been tipsy. It's the trial judges that get tipsy. They have to make the quick rulings.
I think that's what the rule refers to.
I don't think it's ever referred to an appellate court.
No, it doesn't. But we are tasked to look at whether the trial court was right, but for the wrong reason.
This is the trial court sitting as an appeal court. I don't think there's any tipsy coachman drills on.
Isn't as the cost issue, aren't they viewing that as a matter of first instance?
Sorry, I didn't catch that.
They're viewing it, the cost issue, the reason that you're on us, in front of us on plenary appeal as opposed to second tier cert is because you asked the circuit court sitting in its appellate capacity to give you fees and costs. You didn't ask the board to do that. I think we've established that. So you're appealing that as a matter of first instance under 9.190. This is much more appellate procedure.
That's true. That's true. But in concept here, I think that the rationale of the tipsy coachman rule is, they didn't have time to consider it. But so I just don't think it's under the purview of the court to pull even this court, it may be, I'm not trying to be disrespectful, pull arguments that were not made and were not even part of the order.
So functionally, if we play off of that and write an opinion, as you've suggested that we do, and we kick this back to the trial court, and then we ask the trial court, sitting in its appellate capacity, to award fees and costs, presumably under your argument, to your clients, then we just ask the trial court to do that, notwithstanding the express language of the rule that requires us to do something to the contrary.
Yeah, well, you just heard that, it would have been a total futility to do that. And, if you can sit there and say, hey, we're going to penalize Sheets and Massey and all these attorneys so that they had to do something that just going to get kicked back in the face if the legislature didn't have the power to do it. There's something wrong with that. And you'll have to agree with me. There's something wrong with that.
I'm not insensitive to your argument.
And
I'm not insensitive to your argument, but like my colleague just said, it's a hard thing when we look at a rule as being, and Florida Supreme Court rules, I'm sure you would agree, are binding on this.
Well, that's what I'm saying. If you PCA it, it'll never hit the light of day. The repression will continue. You know, it's no
Or the
time-
next time that this happens, you can file a motion with the lower tribunal.
It's
and
not
say,
gonna
"Look,
happen again. I don't represent these people. You know, it'll never happen with me or happen with anybody, 'cause, you know, it'll have to happen with somebody else. I don't practice in this court, you know. But, you know, if you PCA it, it's just like shoving this deep problem under the rug. The Supreme Court will never get a chance to look at it. You know, it's,
Unless you do make a rules inquiry on it and refer it to a rules committee, because then they will look at it.
yes, but that certainly will not leave us without remedy. And they may or may not look at it. If an opinion is written on it, that will certainly, ding, 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 they better do something about this.
Wouldn't the better case to write on to give someone a heads up that this is functionally a problem, perhaps be a case where someone tried to file it in a lower tribunal in accordance with the rules and then did not do so, could not seek relief? Because right now, without any record support for it, we're just sort of taking everyone at their word, and I have no reason to question whether it's true or not, but we're just sort of taking everyone at their word that the board wouldn't and couldn't have done anything with it. And because of that, now we're going to order the circuit court sitting in its appellate capacity to do something that no appellate court does.
Well, I don't think that case will ever come along. If it does, it's gonna be few and far between, and just to leave it hanging, what you're leaving hanging is people like Massey and Sheets. They certainly have the authority to take their home, penalize them, cost everything, and they're stuck right in the middle of this. In a very arcane situation, which, you know, I'm asserting that the whole thing now, it violates due process. If I have to follow a rule, it's meaningless and I can't even follow because I've got to follow with that authority. That makes it unconstitutional. The rule, can the Supreme Court rule be unconstitutional? Maybe so. Let's try it and see.
But I mean,
But, you know,
in that context, if that happens in the way that Judge Brownlee said it might happen, then that certainly would allow the city to say, look, our hands are tied. And I'm not insensitive to them either in the context of, hey, we only act as prescribed by statute and there's nothing in the statute that says that we can do that. I recognize for both of you gentlemen that this is not an ideal situation.
I'm just saying, don't take the easy way out. It's not fair to us. It's not fair to the courts, you know? It's really, you know, it's immense trying to take one of these cases and find justice for somebody whose civil rights have been violated.
I do assure you, sir, that we are mindful of that. I was an appellate litigator myself. I know what it's like to write a brief. I know what it's like to represent people in all different kinds of courts. And oftentimes we PCA for a lot of different reasons. We don't do it because it's necessarily the easy way out. We do it after we are prepared, after we've conferenced the case, after we're now having oral argument in the case. So if we decide to do that, there will be a good reason for doing so.
Okay, well, I really didn't mean to sound offensive, you know.
There's no offense taken. I
That's
just
kind of-
wanted that point to be
That's
clear.
kind of common vernacular. You probably felt that way yourself sometime, you know? But, no, I didn't mean it that way. It's not, but I think this case, you know, deserves to be, you know, go back and think about it again with the arguments. I hope you hadn't pre-decided it. You gotta understand what it said. There's simply no way, it'd be just like throwing, you know, paper airplanes off the Grand Canyon. They're not gonna stick anywhere. You know, what do we do then? You know? And this is all, and the end result of that is some poor bloke got fined $500, got to pay $800 or $900, $1,000 to appeal it. So he's stuck. He said, hands up. Go ahead and take my civil rights, take my constitutional rights. I can't deal with it. Just put my, you know, that's what we're facing here. And this court has the authority to look deeper into due process situations. I wish I had longer to go into that, but I hadn't even touched on my other cases and the statutory. You know, we hadn't even touched that. The time's run. in the statute, hadn't even got to the other points. Due process is a powerful, powerful thing that has to be considered by this court. Is there a real opportunity to be heard in a meaningful way? How meaningful is it, a situation like that? How meaningful is that? Somebody that's stuck before a kangaroo court?
Let's just not use that term if you would.
Well, Fifth District used it,
If you wrap up, sir.
Yeah, sure, but, I'm not trying to be disrespectful, I'm just saying the Fifth District use those words, it says in some cases it might be a kangaroo court. So, I think, not only was arguments made about children, in the briefs, Mr. Levin cited the sedition acts. He said, well, look, these sedition acts.
So you're over your time. If you would just conclude, sir. Is there any last thought?
Yeah, please just do what's right in this case, and let's hear something from this court that can, thank you.
All right.
Appreciate
Thank you for your
time.
arguments.
All right, you're being recessed.
Thank you.
All rise. All right, please be seated. We'll be back on the record. Our last case for this morning's session is 23-2544, the state of Florida versus Joseph W. Hughes. Before I ask about rebuttal time, let me just advise everybody that the case is being streamed live via YouTube. And if you haven't already silenced your cell phones for us, we'd be grateful if you did. You, Ms. Giles?
I am.
Typically 5 minutes for rebuttal, but I can move that either way if you'd like.
5 minutes is perfect.
Whenever you're ready.
Thank you. May it please the court. My name is Marissa Giles and I represent the state of Florida in this case. The state is seeking reversal of the trial court's order granting the motion to suppress for 2 reasons. The first being that the trial court required proof of actual speed instead of applying the objective, reasonable officer standard when determining if there is reasonable suspicion for the traffic stop. And the second reason is that the trial court should have allowed Officer Watson to testify to his pace speed for the purposes of establishing reasonable suspicion.
Is it reasonable suspicion or probable cause?
Your Honor, we would submit that it would be a reasonable suspicion.
Why?
Because the Florida Supreme Court has held that it is reasonable suspicion.
Is that what it held in Holland?
I'm sorry, Your
Is
Honor?
that what it held in Holland?
I can't speak directly to Holland, but I know that Hilton has specifically said.
It seems like, though, when you've got a situation where, I'm sorry,
No, you're fine.
you've got a situation where the United States Supreme Court in Wren has said that objective probable cause is the standard. Holland specifically says we adopt Wren, that objective probable cause is the standard. And then it's not cited in your brief, but it's cited in your colleague's brief. Our court, Judge Mize and I were on that panel, and Hickman said objective probable cause is the standard. It would appear that the situation that you're putting us in, and we can overrule ourselves if we en banc. It's deeply problematic to overrule Florida Supreme Court and the United States Supreme Court on that issue. So I understand in the context of Hilton, but you're talking about objective probable cause. So I'm very curious about the state's argument that it's reasonable suspicion and the basis for why we would be able to do that.
So first, Your Honor, I would argue that that issue is a little bit outside the scope of this specific case because the court's order specifically applied reasonable suspicion.
What if it was wrong?
Well, if it was wrong, that could have been cross-appealed by the defendant in this case, but specifically the judge ruled it was reasonable suspicion. They correctly ruled that. Now,
Well, hold on. I mean, they're the appellee. They don't have the same presentment obligations you do, right? If we're going to review whether the order was right, we have to review the standard which the order applied, do we not? Are you saying we should just look at the final order and say it applied the completely wrong standard and just continue to apply that? Is that how appeals work?
well, I would argue that that specific issue was not before the trial court, so it would be preserved. And
The
further,
trial court didn't have to decide what standard it was applying?
the trial court did, and it applied the reasonable suspicion, but
Okay, so that issue was directly before the trial court, what standard to apply?
in a sense, I would agree with you.
Counsel, in a sense, or obviously and clearly, in order to decide the motion, it had to decide what standard it was applying to decide the motion. How could you possibly decide the motion without deciding what standard to apply? And the court did in fact pick a standard to apply.
And I would agree with you on that the court did in fact pick a standard and it picked reasonable suspicion.
Was that both parties asking, excuse me, Chief,
You're good.
apologize. Was that both parties submitting to Judge Duckworth that that he needs to apply a reasonable suspicion standard?
I would say that there was no, well, I would say that the state obviously submitted. I think that they, said that over and over that this is a reasonable suspicion standard. And it was never really a debate at that hearing in the record. There's no debate about whether it's
So let
probable cause.
me phrase it this way, and it's a different way of looking at it. It seems like if we do what you want us to do, we're going to reverse and we're going to write an opinion. And if we write that opinion, and say that the reasonable suspicion standard applies, have we not overruled the United States Supreme Court? Set aside Hilton for a second. Let's assume I agree with you and that there's a direct conflict between Florida Supreme Court and I don't agree. But as it relates to the United States Supreme Court, are we just going to be like, United States Supreme Court, you're wrong on this Fourth Amendment issue?
I would argue no, Your Honor. I mean, I would argue that Wren, in a sense, says that the standard is reasonable suspicion because
It directly quotes probable cause.
it does, Your Honor, but it does say, and I'm going to read it for you, it says that the automobile stop is thus subject to the constitutional imperative that it not be unreasonable under the circumstances. And then I think that's where we get our proposition that, probable cause, to have probable cause, you have to have reasonable suspicion. And so I think that the terms are used interchangeably, but for the purpose of a traffic stop, all you need is reasonable suspicion.
Does that matter? I mean, do you think that you prevail under either standard, or is this dispositive to your issue?
Your Honor, we would prevail under either the probable cause or the reasonable suspicion standard, and that's what we argued initially in our initial brief, is that based on all of the testimony of the visual estimation, beside the whole issue with the pace, if you had all of that, you would absolutely have probable cause.
So let's talk about all of that for a minute, okay? And we'll just call it probable cause
Okay.
for sake of argument, all right? And I'm not making a decision one way or another as to that, but we'll just move forward with that basis. So if we think about visual estimations, I think you cited 3 cases for this proposition, that visual observations would be sufficient to give rise to probable cause, right, in quotes, for that stop. What do we have here? We have, in my estimation, we have the defendant coming hot off the line, so to speak, to put it colloquially. And in addition to that, we would have this testimony regarding the pace. My first question, and then I have a follow-up, is there anything more than that?
Absolutely, Your Honor.
Okay.
Besides just the acceleration off the line, we have Officer Watson's testimony that no other cars were passing the defendant. There was a gap in distance between the defendant and all the other cars. The defendant's vehicle was traveling faster than all the other vehicles on the road. And then Officer Watson himself testified that he had to make a U-turn to get behind him, and he himself had to accelerate off the line. Or not off the line, but accelerate to catch up with him.
Which of those things, I mean, probable cause, I see probable cause of a crime, right, or some infraction. So which of those things indicates an infraction?
All of those taken together would,
No, give me a specific one. Which one of those instances, tell me what about that tells you an infraction probably occurred. If I see 2 cars driving and one is driving slightly faster, without more, why does that make me think there's an infraction?
well, I think the acceleration off the line is probably the best one of those factors.
Is there a statute I'm not aware of that makes it illegal to accelerate at a certain pace?
No, Your Honor, but we do have to look at all of those factors taken together.
Okay, but at least one of those factors has to point to something illegal. Which one of those points in some way to something illegal? Give me a specific. What's illegal about it?
There's nothing illegal about accelerating off the line. I would concede on that
Nothing
point.
illegal about that. Go through the other. Which one of those? You said those give probable cause, so that means illegal, right? Probable cause is to point to illegality. Which one of those points to something illegal?
I would submit again that we have to look at all of those from the position of a reasonably objective officer, which is the standard that has to be applied, and that's what the court ruled in Hickman.
If I see 5 things that are not illegal, how does that give me probable cause of illegality?
Taken together, it can give probable cause to
So
illegality.
5 non-illegal things equals an illegal thing?
Perhaps, taking it all into account from a reasonably objective officer who's trained to look at traffic infractions.
How many legal things do you have to see before they turn into an illegal thing?
I can't put a number on that. It has to be taken from that perspective of a reasonably objective officer. So I can't tell you one of these factors points to the illegality. It has to be taken all into account.
Okay, is that opinion you'd be comfortable having out there? Here's all these things that are perfectly legal. People can get pulled over for that.
Well, I think there are opinions out there. I mean,
Which
that's
one?
what all of these visual estimation cases essentially say. I mean, looking to the factors in Edie or Joy,
Yeah,
we
but
have,
those visual estimations were of speeding, which is illegal. The things you just noted, none of them were illegal. Accelerating is not illegal. Driving faster than another car is not illegal, right? The visual estimation has to be visual estimation of something illegal.
right, but in Edie and Joy, the factors that pointed to that illegal speeding were the dust That is not indicative of anything illegal. The screeching tires, I'm not aware of a, maybe there is a statute out there that says, screeching tires is illegal, but I'm not aware of that. So it has to be a totality, for lack of a better word, looking at all the factors that may not be illegal, but taken together point to, from a reasonably objective officer standard, something illegal.
And perhaps the pace might provide a plug-in for that, so to speak.
Correct.
But I'm mindful that it has to be the totality of the circumstances. So if you were to look at the pace issue, and we look at what that officer's speedometer might have read to determine whether or not the defendant was in fact speeding, where is that in the record? Is it somewhere in the record?
The actual speed?
Yeah.
No, Your Honor, that was not in the record.
Is that a problem for you from a preservation standpoint?
Your Honor, I don't think so. I don't think it's an issue for preservation.
Why don't you have to, if you're going to argue that I guess is the proper thing to ask, is are you going to argue that the pace supports the probable cause determination, or that probable cause can be determined without that?
I mean, for the purposes of our brief, I believe that probable cause can be determined without that. But if we had the pace, absolutely, that is going to take into account that totality of what probable cause is.
So then, wouldn't we need to know what that speedometer read?
I don't think so, Your Honor, because we're asking for this court to remand for,
What if it read 15 miles an hour?
well, then I think that would be problematic, but
But isn't that the whole point about a proper, and look, I recognize you weren't the lawyer who was doing this below, but isn't that the point of a proffer? Which, if it says 145, certainly that would lend a little bit more credence to the officer's visual observations, I think.
And I would
But
agree.
what if it said 8? I mean, then the whole thing just doesn't matter. Now, we can speculate that it doesn't say 8. He probably wasn't ready to testify because it said 8. But what if it said 36 or 35 and a half? And then calibration becomes a bigger issue.
Right, and at the same time, I mean, they don't need to prove actual speed. I mean, they never needed to prove what number. They just needed to prove that he had, we'll go probably.
But how do we know,
suspicion, but-
how do we know, this is the preservation question, how do we know without a proffer whether that matters?
Well, first, I think that it could be inferred from the testimony that the pace clock was going to reveal speeding, specifically because the officer testified, I paced him, I pulled him over, and then I would not have pulled him over. This whole 2 ways to pull someone over, that was a big part of the trial court's order, but he said, the 2 ways I stop someone are pace and radar, essentially. So we can have that inference that because he paced him, he stopped him, and he said the only reason I would do so was if he was speeding, and I verified that with my pace. And I think that that's in the testimony. But we're asking this court to remand so that testimony can be brought out.
I guess that kind of goes to the whole point. I mean, you're saying, well, he indicated it is important, so it must have been that it was going to show illegality. He testified to all these other things you're saying show probable cause, and none of them were illegal. So you're basically just asking us to assume the testimony would have shown illegality when there's really no reason. I mean, you could pace a car at any speed. That just doesn't show illegality, which that's the whole point of proffer, is to preserve so we would know.
Right, and
Because if it is 15, as Chief Judge Traber said, then wouldn't it be harmless error?
well, in that sense, perhaps it would be harmless error. But taking the testimony that we have, obviously it was going to show speeding. But aside from that, we have all of this stuff that points to the visual estimation of speed as well. And he can pull over based on that visual estimation and have probable cause or reasonable suspicion as we're submitting for a traffic infraction.
What's the relief that you're requesting?
We are requesting that this be remanded, reversed and remanded for the trial court to first apply first have the state have Officer Watson come back in and give that proper testimony about what his pace clock showed without having to provide proof of calibration. And then for the court to apply the proper standard, which we would submit is the reasonable objective officer standard. Because he did not apply that. He required proof of actual speed in his order.
Reasonable objective officer standard, there a passage in red when the Supreme Court explicitly said this is a bad standard? Here's why we reject it. It basically said that would require judges to draw upon the collective consciousness of law enforcement, which is impossible, and that's why we're rejecting that.
Perhaps, but, that is the standard. This
Well,
court
hold on.
applied
If
the
the
standard.
Supreme Court issues an opinion saying this is a bad standard, we're rejecting it, that means it's not the standard, doesn't it?
Right, but the Red Court did not hold that that's not the standard. The Red
But
Court,
there's literally a passage in the opinion, if I'm remembering correctly, where they said, this was a bad standard, we're not going to use this standard. It would require judges to draw on the collective consciousness of law enforcement, which is impossible. Therefore, we're going to go with objective probable cause. I mean, it seems like they literally said, this is a bad standard, we're not using the standard.
Your Honor,
Am I just misremembering the opinion?
I'd have to go back and read, I don't recall that. I
That's what we
recall
said in Pickman.
that,
The guy didn't even go over there because the appellant was parking in a no parking zone. It was just in a no parking zone. That's what objective probable cause means.
Mhm.
The reasonable beliefs of the officers matter not a whit.
right,
It's a difference between objective and subjective.
the subjective point does not matter.
You're into your rebuttal.
Thank you. I will go ahead.
Counsel, may I ask you, when you come back up for rebuttal, would you look through the record if you have it and see the testimony that you believe, you stated that the officer verified that he was speeding through his pace?
Mhm.
Would you see if you could locate that in the record for us?
Yes, Your Honor. Thank you, and I'll reserve. Thank you.
Mr. Harmon.
Morning, Judge. Stuart Hyman, I'm here on behalf of Mr. Hughes. May it please the court.
Mr. Hyman, can you start with the same question we asked her? I think we've all got a question about the standard, right? We all, seem to think there's a good argument that the wrong standard was used. How do we not reverse and say use the right standard? Not to say the trial, not to say the result.
I don't know that the judge used the wrong standard. If you look at the Wren decision, there was a one paragraph I cited it, and I think it was brought up, but not all of it was brought up in the oral argument just a few minutes ago. Wren said an automobile stop is thus subject to the constitutional imperative that it not be unreasonable under the circumstances. As a general matter, the decision to stop an automobile is reasonable where the police have probable cause, that part was not read, probable cause to believe that a traffic infraction has occurred.
A probable cause.
Yeah.
And this
So-
judge used a different standard than that.
Well, I don't know that he used a different standard,
Let me
but,
read paragraph 8 of his order.
yeah, well, I know, but, well, I guess what I'm saying is that for a traffic infraction, reasonable cause means probable cause.
I
According
mean, I
to
understand that there is an element of reasonability that goes into probable cause, but reasonable suspicion and probable cause are two very different things.
Well, they are, and actually,
So what is a
there's
reversal?
a difference between founded suspicion and just suspicion also.
Sure, but if he's gonna say that the proper test to determine the validity of a traffic stop is whether the officer has objective, reasonable suspicion to believe that a traffic infraction has occurred, are you left to argue with us that he made the right standard because he really meant probable cause?
My position is it's probable cause.
I think it is.
It always has been.
Yeah.
But I'm not gonna tell you that things in different opinions have,
You're in a weird position because I think you argued that below.
Yeah.
And you kind of lost on the standard issue. You didn't get the tougher standard you wanted, but then you won under the lower standard. So now
Right.
you're in a very tough position of,
well,
Preserving your client's
my
rights.
position is that under either standard, this stop here was basically, the crux of this case is that if a police officer believes somebody's speeding, that's good enough.
But what about, before we pivot from the standard, let's talk about objective versus subjective, right?
Okay.
So my recollection is that the trial court here really harped on this officer testifying that there are really two ways he could pull somebody over, and that he's limited within those two options, right? And one would be, the radar gun, and then one would be through pacing. And so to the extent that the trial judge relied on that, is that relying on the subjective beliefs of one officer versus the true objective standard?
That was the question when I was writing this brief, that I was kind of looking at. And the Dobrin case is the case that talks about the asserted basis for the stop from the Florida Supreme Court. And that's the one that says that we can't look at the collective consciousness of law enforcement. We have to look at the asserted basis or the basis asserted by the officer. And the lower court did rely on the Dobrin case.
But don't you have a different situation in Dobrin where the only thing that was in Dobrin was not the testimony of a live, breathing officer whose credibility based on visual observations that you could take or leave. You've just got a cold arrest report in Dobrin that flat contradicts, the argument that the state was making in that particular case. So I guess I'd go back and ask for a crisper answer as it relates to my colleague's question. If the standard really is objective probable cause, and the testimony from the officer is, well, I only pull over on 2 reasons, that doesn't matter, does it? If there's another reason out there, wouldn't that be good enough?
I don't believe it would be.
Why is that, if we're talking about objective probable
Because if you
cause?
go down the Dobrin decision and you look, and I realize it was only an affidavit that was submitted, but the principle, the legal principle that was applied to that affidavit would be no different. An affidavit is a police officer writing down, this is my probable cause. It's no different than a police officer coming into court and saying, this is my probable cause. And then a judge has to look at it and say, okay, based on what this officer testified to, is that sufficient for probable cause? But in both situations, you have to look at the basis asserted by the officer for the stop. In this case, the officer's basis for assertion was he had a pace clock.
Do we have to,
We're gonna count how many times we do that today.
do we have to unbog Hickman then? Because in Hickman, which you did cite in your brief, the officer specifically said, I was not going to do anything because she was in a no parking zone. And we basically said, that doesn't matter at all, because the standard under Wren and Holland is objective probable cause. Your subjective intentions don't matter.
And Council, I think what that goes to, and I'll just ask you to supplement and obviously answer the question, but Dobrin doesn't say we overrule Holland.
No.
And obviously it doesn't say, like, what Holland did was told lower courts how to read Wren, right? Like, maybe there's different ways to read Wren, but the Florida Supreme Court gets to tell us how to read it. And Holland is the case where they said, here's what we think Wren means, and obviously DCAs have to follow it. So the reason we know Dobrin is different than Holland is because it doesn't say we overrule Holland. And we know courts do not overrule themselves sub silentium. The Florida Supreme Court does not. So those cases must be distinguishable. And our case is clearly under Holland. This is a traffic stop, just like Holland was.
The reason why, and to answer the question, if you go further down in the Dobrin opinion and you look at the reason why the court came to the decision it came to that, on 2 of the issues, the state tried to use that, well, an objective officer would have stopped this vehicle potentially because the driver was tired or ill. And they said, well, that's not the basis that's in the report that the officer said he made the stop, so therefore we can't use that.
Right, there's no support in the record. And I guess my rejoinder to that would be, the trial court never got there in your case. And let's just set aside calibration and speedometer for a second. There was never any, I believe you or I don't believe you about visual cues on speeding. So for example, you in your answer brief, I think, argue this. You're like, look, wouldn't it have taken him a lot longer to catch up after he turned around? There's nothing about, it wasn't like this was a funny car that was on the line. There wasn't flames shooting out of it. It wasn't popping up on its wheels when it took off. So you're making a credibility argument on appeal. And to me, it seems like, I'd ask you to react to this, it doesn't seem the trial court ever got there because it misapplied the standard.
Well, I think that we argued about credibility because a lot of times the state would say, well, he was doing this, and the judge, I think at one point in time said, well, how do I know how fast he was going? And there's numerous references in the record where these kinds of diatribes kind of came up. And, but I think he made a credibility determination.
Where in his order do you think?
I don't think he specifically said it in his order.
I mean, he certainly didn't say anything in the lower proceeding, and all three of us were trial judges, and we, defer greatly to findings of credibility. If there was a finding of there, of just like, look, be this all as it may, standard, no standard, I don't believe you, and that's the only testimony, I think it's a different appeal, don't you?
Well, no, only because in this particular case, the police officer, at least when I was doing cross-examination, and the car was coming from the stoplight, he flat out said, I never made a visual estimate of the speed of that vehicle. And then we got into that by the time 30 seconds later, a quarter, half a mile later, he gets up to where my client's vehicle is. My client's vehicle is only 5 car lengths in front of the next vehicle. There was a lot of conversation going back and forth about that, and I think impliedly, I'm not going to tell you expressly, but impliedly, there was a credibility determination that was made, and without there being a speed measuring device of some nature, the judge was saying, Judge Duckworth was saying that there's just insufficient evidence here. Even, I guess, if he's applying the reasonable suspicion standard as opposed to probable cause standards, there just was not enough. So that to me is a credibility determination, especially when everybody was arguing below as to whether this was enough to go ahead and stop the vehicle, because we went through that argument. So yes, I'm going to say there's nothing in the actual final written order that says I don't find the officer credible, but it does say that without the speed measuring device, there was not probable cause or suspicion.
Yeah, but he's kind of saying, not probable cause, at least not, I don't think it was justified, it is justified stop based on the 2 prongs the officer gave us. And the distinction would be that objective probable cause would be able to allow him to go outside those 2 prongs if I pull people over for pacing or speed device, wouldn't it?
Well, if a police officer testifies, as he did in this case, that I will stop people just on visual, that's telling you that he doesn't have arguably enough faith in his own ability to visually estimate the speed of the
Counsel,
vehicle.
that's Hickman, right? We've got Hickman, and I think Hickman was just applying Holland. I don't think we had any discretion in Hickman. Officer said, I didn't think there was a traffic violation. I didn't think I had any basis to stop this person. And yet we found objective probable cause because even though he said that, he also said the car was in a no parking zone. And there's a picture of the car in a no parking zone, right? And the officer said, I didn't think I had a basis to stop her. And we found objective probable cause because there just was. The car was in a no parking zone. Everybody stipulated that. Nobody disputed it. So the officer's belief that I didn't have a basis to pull this person over, at least under Hickman, and I think under Holland, is not binding on us as to whether there was objective probable cause. Is there?
I can respect that, but I think that you also have to look at factual situations. Yes, if the car is sitting in a no parking zone, yeah, there's a violation there. But when it's an estimate of somebody speeding, or I believe somebody's speeding.
Hey, can I change your factual scenario though?
Okay.
What if your client was driving a funny car? And what if it went up on its hind legs, shot up flames from the back, and took off the line?
Then we'd probably be under Edian, what was the other one?
So this is Gallardo. And this is kind of what I want to talk to you about, because from Judge Mize asked a question of your colleague in this standpoint. Hey, there may be nothing in the state statutes that say coming off the line fast is in itself a crime.
Right.
However, if there's flame shooting up at the back and flips off and it rockets off the line, maybe it's not speeding when it comes off the line because it's going from 0. But could a reasonable officer at that point, using probable cause, say, you know what, I'm going to be pointing the other direction, but that car's speeding.
Well, yeah, but he also said that he didn't make an estimate of the speed when it was coming off the line.
But then he
Does
doesn't
He did.
take care so it's logical.
Does he need to?
Well, I think.
Does he need to say that it's going 38 versus it's 55 or 104? I mean,
This is the whole problem that I see with these opinions about speed, okay? That an officer is just driving down the road, and I think that car is speeding. He can do what he wants to do, I guess, but at some point in time, the court has to determine whether that's sufficient or not.
credible.
And credible.
But we have something more in this case, right? We have these sort of visuals that were pointed out by opposing counsel And then in this case, he said, which I think makes your point, I need something more, right? This officer, for whatever reason, he's a stand-up guy and he's gonna use his radar gun or he's gonna use his pace. And he used his pace in this case. And if he testify as to all of those factors, I wrote notes about what she was stating, the acceleration, no other cars passing, the gap in distances between his and other cars, traveling faster than the other cars, had to make a U-turn and paces him and then determines he's speeding. Now don't we have a bigger picture about probable cause regardless of whether we know for a fact what his speedometer absolutely says how fast he's going?
No, because I don't know how he interprets his speedometer. He could at the time, and also we're dealing a quarter mile, half a mile down the road. We don't even know what came up on that speedometer.
And he had to accelerate to catch him, according to
Well,
testimony.
that tells me that my client's going slower than he is because he's accelerating. He doesn't know how fast my client's going. And all these cars, I guess there was 3 of them, they were all apparently traveling the same pace. And a quarter to a half mile later, 30 seconds later, my client is only 5 car lengths in front of them, which is probably the same 5 car lengths, or could be argued the same 5 car lengths as when he left the light in front of them. And we don't even know if they were delayed in leaving the light. He doesn't.
Yeah, but, so, assuming the pacing showed speeding, right, which, the testimony wasn't in, the fact that he's not that far in front of the car, I don't think that helps you. That might just mean they're both speeding, right? Like if 2 cars are speeding, it's not like the officer's not allowed to pick which one to pull over. He can't pull over both. So the fact that he wasn't that far, assuming the pacing testimony had come in.
Oh, right.
And he said, all right, I paced him and he was going, I was pacing at 50 and I was at 50, the speed limit was 45 and he was getting farther ahead of me, right?
Sure.
The fact that another car was doing the same thing wouldn't discount the probable cause.
No, but you would think he would stop there. But in this particular case, we can only go on the record that we have.
Can I ask you just a general question about probable cause then? Does the officer need to be right in terms of illegality to have probable cause 100% of the time?
Well, I think courts have decided that officers make mistakes by
So-
reviewing what they do. Probable cause is not 100% foolproof.
Right, you could have a situation, for example, and I think about the tinted window cases, where
I think about those a lot also.
I know you do. So that's why I wanted to ask you about it, because let's say, for example, that this officer was wrong, but that the trial court theoretically on remand says, I think that I find you incredibly credible, the highest level of credible. You seem like just such a credible person. And while I don't know exactly, I'm going to give you the benefit that if you were making a mistake, it was a good faith mistake and that you had probable cause to pull over. So first off, I know the law supports that. And I'm not asking.
It does. I don't agree with it, but it does.
Yeah, I'm not asking you to concede your case. I never would. But if you had that particular situation on remand or below, this would be a very different appeal for you, wouldn't it?
Well, it could be, but Judge, wouldn't that be the case every time? I doubt, there's very few records that I've ever seen where the officer wasn't, I guess, trying to operate in good faith. He just doesn't recognize probable cause when he sees it.
But this is why you're good at cross-examination. Because at the end of the day, the credibility determination is what controls there, right? Because if the officer says, for example, I was 3/4 of a mile away when I saw this U-turn out of the corner of my eye and I happened to be on the phone the entire time. Okay. It's just a different scenario.
Well, it is, but the point is that there's not a stop. Well, I won't say there's not one, but the majority of stops, you could always say that the officer was acting in good faith. This is where there is a part of this brief, we got a little bit into it, with whether or not there is this good faith exception. I don't read it into the Constitution. Everybody's got their own views of whether you can add things into a Constitution or not add them into a Constitution. But the point is that if we were to follow certain precedent, you can't read a good faith exception into whether there's an unreasonable search and seizure under the Fourth Amendment. But it has been done. And I don't necessarily agree that you can do that, but again, cases go different directions, but taking that down the slippery slope that it would lead to is that every case that an officer stops a car, he could say, well, maybe I was wrong about it, but in good faith, unless it was some real blatant bad thing. The good faith would just take over the entire unreasonable search and seizure law.
Well, counsel, I think what you're saying is, let me ask it this way. Assume that we decide the court applied the wrong standard, okay, and that it should have been objective probable cause. Then I think we would have to reverse unless you could convince us that on this record, nobody could find probable cause. There couldn't have been competent substantial evidence for a probable cause finding.
Right, that's my point. My
Okay,
point is.
Give me your best,
My
60
point
seconds
is,
or 2 minutes of,
okay,
you should PCA this, because even if the standard was wrong, there was no competent substantial evidence of probable cause, and the state shouldn't get a second bite of the apple.
it's tipsy coachman here.
What I'm saying is make that case for me.
My
that on this record-
argument is that the standard should have been probable cause, and the facts that were in the record below did not support probable cause to stop this vehicle. In my position, it didn't even support reasonable suspicion. But if we're gonna remand it down for probable cause, and the judge is even gonna apply a higher standard than reasonable suspicion, then if he didn't find there was reasonable suspicion, then one would think he's surely not gonna find probable cause.
Well, we didn't let the pacing testimony come in. So now imagine the pacing testimony comes in. Imagine we think that should come in.
Well,
Does
then,
now does it have a
then
chance
we-
to get
then-
probable
then-
cause?
well, I guess there could be, yes, because I think he even said that if there was a speedometer there that showed that the individual was speeding and he could rely on the speedometer, but then we get into cross-examination about whether it was calibrated properly or
Well, I'm
not.
not saying you won't get the crossing below,
Yeah,
right?
yeah.
But I'm just saying, if we decide that the pacing test, that A, the probable cause standard, the standard was wrong, and the pacing testimony should have come in. So we don't know whether they could have met the probable cause standard, because even if we don't think they met it yet, they didn't get a chance to do the pacing testimony. Do we not have to reverse if we find those two things?
I would have to say yes. If you're deciding that the speeding, the speedometer should come into evidence, even though our position is that it shouldn't, because the witness wasn't competent without necessary predicate there, and the state didn't try to prove a predicate.
Does that go more toward weight or admissibility? I mean,
I
would
think
you
it does.
then have a chance on cross-examination if that officer testifies and my speedometer revealed that I was going 65 miles an hour, and then don't you then have an opportunity on cross to show the finder of fact, but was it calibrated? Has it ever been wrong before? When was the last time you checked it?
I would agree with that, except first you have to get through the threshold of whether it's even admissible in evidence, whether the officer is competent to be able to testify concerning a speed measuring device without the requirements that are required under the rules.
Even to just assert probable cause, when he's not trying to prove whether or not someone's speeding, right? He doesn't have to be right. We know, correct? I mean, do you agree with that? He doesn't have to be correct that he's speeding. Could be a mistake of fact, perhaps, like the window tinting. And so go ahead, sir.
The statute, I go by statutes and the rules. The statutes don't say, we're in a court proceeding, so the rules of evidence are applying. The statute is setting the rule of evidence for the admissibility of a speed measuring device. The rules are setting the threshold for the admissibility. Once you get through that hurdle, if you're the state, if you get through that hurdle and you get the speedometer reading in, yes, then I can cross-examine and say, well, they didn't do it on a wheel dynamometer, and the rule says it has to be on a wheel dynamometer. But they have to establish the initial threshold first of getting it into evidence. This is a procedural rule of evidence, basically, that's been put in Florida Statute 316.1905, because it specifically says that an officer is not competent to give evidence, and it just says in a court proceeding. It doesn't say whether it's a suppression hearing or whether it's some other type of
Did
proceeding.
the affidavit make its way into evidence where the officers asserts the basis for the stop? I could think of a lot of reasons why it didn't, but
I
is
don't
that
think
in front of
it
Judge Duckworth?
I don't believe the affidavit got in there, because I saw an argument about the affidavit, but I didn't see where it ever got into evidence.
And because the affidavit does provide the speed, correct?
Well, the affidavit will give you the conclusion of the speed, but it's not going to establish the predicate of whether the,
I understand your argument in that regard.
yeah.
Well, I think that goes to the preservation issue, and I want to give you a chance to address it. If the affidavit didn't come in, I think you heard Judge Brownlee's question to your colleague. Do we have any testimony as to the speed at which he was pacing him?
No, we don't. Not that I'm aware of.
How does that affect preservation?
Then actually it's a waived argument then.
We have you over time. Thank you for your
Thank
presentation.
you, I appreciate it. Thank you.
And Ms. Giles, will give you another couple minutes if you need it.
Thank you, Your Honor. All right, I do have a couple of points on rebuttal, but I do want to point out those record sites for you, Judge Brownlee. I can't recall what exactly you were asking about, but I do want to point to page 197.
The speeding conclusion, because right now, we don't have anything showing, set aside the fact of whether you have to establish he's speeding, okay? But it goes back to Judge Mize's point, none of those factors that you listed at the beginning of your argument demonstrate that anything really improper is going on. There's nothing illegal about any one of those things. I'm mindful of your point, we gotta take them all together. But then we have this outlier issue of the speeding. Y'all don't, there doesn't seem to be evidence about what the speed was. But you stated to us that there was something in the record that the police officer's testimony stated that he paced him and determined, he verified that he was speeding with his pace. And I was wondering if there's something that concrete in that transcript, which I have reviewed.
So perhaps that specific comment was a little bit taken out of context, because I think what I was pointing to is on page 207 of the record, which said, let me read it exactly, which says that he verifies essentially or would not pull over without pace.
Oh,
That's what
I
I
see
think
what
I
you're
was
saying.
trying to say.
Okay.
But I do want to
appreciate
point to page 197, which says, I believe Mr. Hyman made a point about how, visual estimation was never taken into account when considering the speed. But on page 197, he's discussing, I saw him at the intersection, I observed the vehicle traveling eastbound, I saw it accelerate off the line, and at that point, I believed it to be speeding. And then after I believed it to be speeding, I paced it. And that's the testimony we have on page 197. And then he kind of goes into explaining what pacing is and all that
I know,
stuff.
but did he say, I paced it and here was the speed?
No, Your Honor, because that specifically was not allowed to be testified to when.
Yeah, but that's my point. When testimony is excluded to preserve it for appeal, you proffer it.
I understand that, yes, and I agree with you there.
Did the state court proffer it?
But to me, it seems like the judge was not gonna let that in. It was not gonna allow it.
Hold on. Counselor, I'm asking you a question, you're answering something completely different.
Mhm.
So when I asked you about a proffer, you said, well, he wouldn't have let it in. Proffer is what you do when the judge won't let it in.
Correct.
You see how it's unresponsive to my question to say we didn't proffer because he wouldn't have let it in?
Yes, I agree.
So what I'm asking you is, given that he wasn't letting it in, did the state, in order to preserve this, have an obligation to proffer what the pacing speed was?
I understand what you're saying there. I don't believe the state needed to proffer here because of the implication of, he says, I paced it, I stopped him, and I wouldn't otherwise stop unless for pace. So in that regard, we do believe that, that argument was preserved for that purposes, but also, the objection was before the court. So, we don't have in the testimony what exactly the speed was. But we also have all of that testimony regarding visual estimation. So at the end of the day, we have what needed to be weighed to find a reasonable suspicion or probable cause, if that's what this court determines. And I do want to briefly address the calibration issue. I believe Mr. Hyman was speaking to it as a rule of evidence. And that goes to our argument with U.S. v. Matlock, which specifically is, the United States Supreme Court says that at evidentiary hearings, the rules of evidence, aside from privilege, are relaxed. And this was a preliminary evidentiary hearing. There is no privilege having to do with calibration data. So if that's the reason to keep it out, that's just, that's not relevant to this. Perhaps it may go to whether or not it supports that proposition, but that does not need to be proven. We do not need to prove speed for those purposes. Your Honors have no other question? I ask that you reverse and remand. Thank you.
We recess. Thank you both.
Good trip back.
Thank you. Where are you going?